LC 481654. It is not on your blue sheet. I do apologize. It passed out of judicial non-civil yesterday morning. This bill...
It's yesterday. Go ahead.
Is it? Okay. Well, this bill allows law enforcement to petition a Superior Court judge in the case that someone whose welfare and safety is being investigated, a child, a disabled adult, or an elderly person who is in a known address, but suddenly is in an unknown address, to seek a court order from a Superior Court judge to check on this person to make sure they're safe. Unfortunately, sometimes people move to avoid welfare checks and further investigation of potential safety issues.
Okay.
All right. Thank you.
Don't see any questions. Thank you.
Thank you, Mr. Chairman.
Yes, sir. Come on up, Steve.
Good morning, Mr. Chairman, members of the committee. House Bill 669 is not on your blue sheet. It came out of a very busy Education Committee yesterday, thanks to Chairman Irvin. But the House Bill 669 would allow school systems to improve access roofing, approve, let me back and start again. It would allow school systems to access roofing improvements on existing buildings using a supplier identified through the Cooperative Purchasing Agency and designated by the Georgia Department of Administrative Services as authorized as to be able to supply. This procurement method is for roofing also makes schools eligible for capital outlay reimbursement funds, or in this case, low wealth schools eligible for low wealth capital outlays, and it's only pertaining to roof improvements.
Okay. Don't see any.
Thank you, Mr. Chairman.
Thank you. Yes, sir, Representative Washington.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I'm presenting House Bill 1442, which is not on the blue sheet. It just got out of state and local yesterday. This is a very simple bill. It prohibits local government from imposing a moratorium on any land development in which a permit has already been issued. We did not have an objection from ACCG during the committee meeting yesterday. GMA did have some concerns. We worked on the language, and they are now happy with the bill, and so I urge your favorable consideration of this bill, House Bill 1442.
Okay, we have a question for you, Representative Evans. Try it now.
Thank you, Mr. Chairman.
Yep.
Representative Washburn, can you give me a for instance, like what's a problem that came to your attention that we would solve with this?
Well, we just believe it's an issue of fairness. If anyone has applied to do any sort of land development project and has satisfied all the local requirements by filing everything that should be filed, and in a lot of cases spending a lot of money in the process, we just believe if the local government has issued the permit that it is not fair to come back and suddenly impose a moratorium after everything has been satisfied, all the process has been done. So we just believe it's an issue of fairness.
But has anybody been denied the ability to build because of something that you're speaking of, this hypothetical?
I'm sorry, I didn't quite hear.
Has anyone been aggrieved? Has anyone ever been stopped?
Yes, it has happened. I'm not sure of the exact location, but there is a project where a lot of money was spent and every requirement was satisfied, and then suddenly there was a moratorium issued after the permit was issued. There is a case, yes.
Do you know how long they waited to start the building process?
I don't know how long they waited. I know they spent a lot of time and energy and did everything that was asked of them, but I don't know the details about how long.
Mr. Chairman, this one is not only not on the sheet, it's not in our book, so I don't have a way to look. So there's no limit. Let's say someone gets a permit and they wait 10 years. I think we all know that the complexion of a neighborhood, things can change. Are you saying in no instance could a local government put a limit on the time that someone could start building if they get a permit, whether that's 2 years, 5 years, 10 years, 20 years?
The bill simply says they cannot issue a moratorium after a permit has been issued. It's very simple. It's a two-page bill.
You'll
says
get
they
a
cannot do that.
You'll get a copy of it and have a chance to
Yeah.
look at it before doing
Thank
anything
you.
else with it. Thank you.
Uh,
Mr. Miller, do you have a question?
Thank you, Mr. Chairman. thank you for your bill. I also don't have a copy of it. Can you, in your hypothetical, tell me the reason why the moratorium was issued?
I do not know the reason why it was issued. It was issued by a city government here. I don't know the city government, don't know who it was, but I do know that they had done everything that was required of them and had spent a considerable amount of money in the process to satisfy all the requirements, permits in hand, and then they were suddenly hit with a moratorium. We think that is unfair. Land development's important to us economically. We're talking about job creation. We're talking about expanding the tax digest. And we just think when people have played by the rules and done what's required of them, it's not fair to issue a moratorium after everything's been done and the permit has been issued.
Okay, and do you have any, not with regard to this particular hypothetical, do you have any sense of moratoriums that have come down wherever that would have, impacted developers who are in this situation? I'm just trying to get a sense for the gravity or the rationale for the moratorium weighted against all of the, smart things that you just referenced for a reason to not allow it.
Moratoriums are issued many times over all types of development. A lot of times it's residential development where local governments are concerned and they just want to slow things down. We see that sometimes. This bill is not about that. So this is a particular case that the bill was introduced because of that case. I'm sure there may be some others, but there was one particular case in which this bill was, why this bill was introduced.
Thank you, and we'll make sure you have a copy of all these for the next meeting, so you'll have a chance to look at them.
Mr. Chairman, may I present one more?
Yes, sir, go ahead.
House Bill 204 is halfway down your blue sheet on page 1. Simple bill that just removes the Department of Public Safety controlling pricing on the moving of household goods. And I'd appreciate your consideration of that.
Okay, don't see any questions. Thank you,
Thank
sir.
you, Mr. Chairman.
Chair Lady Mathiak.
Thank you, Mr. Chairman, committee. My bill is not on the blue sheet. It came out last night of health. It's House Bill 1089, and the LC number is LC 46150-4S. What this bill does is allow ivermectin to be sold over the counter without a prescription. It will be treated similarly, excuse me, as Sudafed. So the pharmacist will counsel with the customer, and it'll be behind the counter. And I'll stand for any questions.
Okay. Don't see a question. Thank you.
Thank you.
Yes, sir. Chairman Gunter.
Thank you, Chairman. I have three bills. The first one is House Bill 1433, the top of page 7. And this is just updates the penalties for practicing law if you're not an attorney. Happy to answer any questions on that one.
1433.
Next bill is not on the blue sheet. It's House Bill 289. This authorizes Georgia notaries publics to perform notarizations remotely over secure video technology. This includes a framework needed to make that remote online notary legally valid and enforceable under Georgia law. Happy to answer any questions on that one too. And then lastly is House Bill 1227. This is model legislation that gives newly registered voters from out of state the opportunity to opt in to their local registrar and Secretary of State to notify the state they came from that they have registered in Georgia. It's already law today, federal law today. This just is a voter service bill to help them notify the state they came from that, hey, I'm in Georgia now and a registered voter.
Okay.
Thank you.
Got a question for you.
Okay.
Representative Evans has a question.
Thank you, Mr. Chairman. I'm looking to see if this one is in the book, so I can ask more intelligent questions. But could you let us know how the committee went? Was it unanimous? Was it divided vote?
I mean, I don't remember.
It's not in our book, so I can't reference it.
I don't remember. We had a lot of
Is that
committee meetings on this.
1227 you're talking about?
1227.
1287, right?
1280.
No, 1227.
1227.
It's not in the book.
This is the voting bill. Can you tell us a little bit more about what it does?
Sure, this is a voter service measure that will go on top of your voter application. It'll opt you in if you decide to. It's completely optional, where you're giving permission for the registrar to notify the Secretary of State, and the Secretary of State to notify the state you came from that you're registered to vote. They'll send information to that state about you to say this person is registered to vote in Georgia. Again, it's hopefully a model legislation that other states adopt, so we are keeping our voter rolls clean from wherever you come from. Again, it's already law, federal law. This is just allowing, a lot of people don't take the time to do it. So
1227, just confirming
Yes.
it's not in the book, and it came out of Governmental Affairs.
it did. We had a couple hearings. Gabrielle, we got them good with the measure. Secretary of State. I think most of the people involved were good with the language.
Thank you.
Thank you.
Okay. Representative Milner has a question.
Thank you, Mr. Chairman. Sorry, just really quick on the 1433 unauthorized practice of law.
Sure.
Is there some issue or problem we're solving for here is my first question. And then who opposed this bill in committee?
Who opposed it?
Yeah, if anyone.
I don't know that anyone opposed it. I wasn't in committee, to be honest with you. I was somewhere else, and it got presented for me while I was not there. But I think there is a problem with some people, some vulnerable populations, getting people pretending to be lawyers to vulnerable populations and trying to represent them, taking their money and not being lawyers. That seems to be happening throughout. There's also trying to reinforce the practice of law as we do closings. If there's other people, parcels in Georgia, you got to be a Georgia attorney. And sometimes I believe that has been worked around in other places because not every state needs an attorney for a closing, and so some attorneys are widespread and dealing with real estate closings. But vulnerable populations is a big component of this.
Did the State Bar of Georgia weigh in on this or ask for this, or what's their position?
So the State Bar has the ability to do it too. This is just separate. This just gives a prosecutor the ability. It's already a misdemeanor. This ups it to a felony. And so it's the exact same language as the misdemeanor, just makes it a felony.
Understood. Thank you.
Thank you.
That's not in the book, and we're making a list of these that clerk hadn't got yet, but we'll see that you get them.
That one is in the book. 1433 should be, is it not? It's on the blue page. Maybe it's not.
1442 is not in the book. Okay, all right. Representative Evans has another question.
Thank you, Mr. Chairman. Sorry, I'm just trying to keep up.
You're good.
Back on House Bill 1227, I'm wondering if the reason that you weren't able to present it is because there was no notice that it was going to be on the calendar. Were you even aware it was going to be heard yesterday?
Say that one more time.
You said that you weren't able to be in committee to present 1227?
No, 1227 I presented. 1433 unlicensed practice of law.
Okay,
That was in
all right.
judiciary.
All right.
Yep.
Was there notice that 1227 was going to be on the agenda?
It
before the
was.
meeting? Okay.
Yeah.
And that was published to the public?
Yeah.
Okay. Thank you.
Mm-hmm.
Okay. No more questions. Thank you.
Thank you.
Representative Franklin.
Thank you, Mr. Chairman. My bill is House Bill 1132. It's not on the blue sheet, but I'm just kind of hoping to throw a Hail Mary here in the hopes that somebody catches it for the win. I like to call this bill the Affordable Housing Bill. And what it basically does is it allows a tax exemption for the building of building materials and construction supplies for homes for 501c3s and Habitat for Humanity, for example, that they get a tax exemption for the construction of those homes. It relates to about $7,000 per unit per savings. Half of that would be from the state and half of that would be from the local municipalities. And that's the bill.
Okay, got a question for you. That's in the book. Representative Miller.
Thank you, Mr. Chairman. I'm sorry, did you say 1132?
1132.
And where is it on the blue sheet?
It's not.
It's in the book.
It's in the book?
Yeah.
Okay, thank you.
Mm-hmm. Okay.
Thank you, sir.
No more questions. Thank you. Yes, sir. Matt Reeves, Representative Reeves.
Thank you, Chairman Parrish and members of the Rules Committee. Have two bills and one resolution that passed out yesterday, so they're not on the blue sheet. The first is House Bill 1254, which has been presented before. No substantive changes. We just merely corrected a clerical error in regulated industries yesterday. It's the professional licensing bill, House Bill 1254.
Okay, don't see a question. Go
And
ahead.
then a resolution and a related enabling legislation that passed out of higher ed, not on the blue sheet, H.R. 450 and House Bill 686. These are the same language that's been on file for a year, with only one substantive change, moving the rate from 24% to 27.5%.
What? Give us the numbers again.
H.R. 450 and House Bill 686. This is online sports betting referendum. The only change is moving the tax rate from 24% to 27.5%.
Yeah, they've just met, and that'll be reported out today, so we'll get you copies of that.
Thank you.
Okay. Yes, sir.
Thank you, Mr. Chair. I have three bills. The first one, they're not on the blue sheet either. HB 968, they were all passed out yesterday. This one's the Kratom bill. This is not a ban. Basically, puts you behind the pharmacy counter like the Sudafed. The biggest thing there, after consulting and a strong working relationship with the Georgia Poison Control Center, UGA Pharmacy School, and I even contacted the University of Florida Pharmacy School to get their input, because they do a lot of research on kratom. And basically, let's get it out of the gas stations, put it behind the counter. Let's do that login system. Allow for online sales as well, as long as they're Georgia registered pharmacy. And then more precautionary statements on the label as well than the advertising restrictions. And that's HB 968, constituent-based bill. We just had someone back home 3 weeks ago die, Andrew Wood, of kratom.
Okay. Got a question for you. And that's
Yes,
not
sir.
in the book.
Thank you for the bill. I remember we've been over here talking about kratom for a long time now. Just I haven't had a chance to look at this bill, but wondering if it maintained the financial penalties against businesses who violate the provisions. Like what's the penalty for the folks who don't follow the rules?
Yeah, once we came in agreement last time with you and others, we kept the same thing, that kind of language the same. We didn't change it. So it's the same deal we did last time, where we kept the clerk really almost hold harmless. The consumer definitely is, because they're relying on everybody else. The only bad guys, basically the manufacturers and the processors, distributors, if they try to trick the pharmacy, or if they try to sell stuff above the legal limits. And as long as the retailer, the owner, or the manager, they get really three times they even mess up on purpose before the high misdemeanor kicks in for them. So we didn't change a thing for that based on what we did 2 years ago.
Okay.
Okay, the next one, Mr. Chair, is HB 969. You heard this one before. This is where a school board member ran for school board, and her insurance rates went up, going from a retiree and state health benefit plan to being a full-time member of the school board. I work with Ledge Council, Department of DCH. They were heavily involved, and HHS on the federal level, to work it where we could make that board member decide if they want to be part-time or full-time as soon as they get elected, and that it wouldn't interfere with Medicare at all. So we've also gotten approval from the regional HHS director for the feds. Still waiting to hear from DC, but we've got the regional graces.
Okay.
This will help school board members who want to run, teachers who want to run. Last one, I call it the EpiPen bill, HB 1056. It's really epinephrine bill. Right now, kids are allowed to walk around with an EpiPen if they have a doctor's note because they have like a tree nut allergy or something like that. This provides for any other type of instrument, such as inhaler or pills, if technology's there. Technology's there for inhaler now to be able to walk around it too. Restrictions, of course, doctor's note, parents' permission, can't use it inappropriately. The staff can get trained, and once they're trained, they're allowed to administer as well. This is a school safety bill. If you like school safety, this is excellent.
Okay. Thank you, sir. Don't see
Thank you,
any
Mr. Chair.
questions. Yeah. Yes, sir.
Thank you, Mr. Chairman, members of the committee. I have a HB 1385 passed out of Regulated Industries yesterday unanimously. It's a department bill for the State Insurance Commissioner. 2 or 3 things real quick. The main points of the bill: it provides oversight for deputized personnel to ensure local fire marshals and state inspectors are in compliance with all the operating procedures. It authorizes the commissioner to issue an immediate evacuation order if the building or structure presents an imminent life safety hazard. And one of the bigger things, it modernizes some of the fees on smoke detectors, which now is $15. This bill raises that up to $100 for the fine on smoke detectors.
Okay, no questions. Thank you. Yes, sir.
Good morning, Mr. Chair, members of the Rules Committee. I'm here to present HB 206, which is not on your blue sheet, but will be found after HB 204 on the first page.
Give us the number again. What was it?
206. It would be found on your first page, but we just made it out of the Higher Ed Committee with the help of the chairman and the other members. But what 206 does, if an individual is convicted of possession of marijuana, they will not lose the Hope Scholarship. They will continue to be eligible to continue their education and become productive members of our society and communities, thus keeping our communities safer. With that, I yield my time and hope for favorable passage of this bill. Thank you. As well as I asked for earlier, which is on page 2, which is on page 3, HB 1013, which is to designate lemon pepper the state chicken flavor. Thank you to members of the Rural Committee, Mr. Chair, and I yield my time.
Okay, we'll have that other one later today, 206. Yes, sir, Mr. Chairman, go ahead.
Thank you, Mr. Chairman, members of the committee. I bring to you today House Bill 1282. That's on page 5, and it'll be the 6th down from the top. It's a pretty simple targeted change to our code. It would make aggravated sexual battery against a victim under 16 subject to the same extended no-limit prosecution timing rules that Georgia law already applies to most of our other serious child victim offenses.
What was the number again?
Is 1282, Mr. Chairman. Page 5, 6 down from the top.
Yep.
And then I have one that was actually passed out of committee yesterday. I know it won't be on your sheet yet, but wanted to just go ahead and briefly mention it. House Bill 1255, that is actually an update to our discovery procedures here in the state that would actually modernize those discovery procedures on the criminal justice side of our law.
Okay, no questions.
Thank you, Mr.
sir.
Chairman.
Okay, any members of the committee have a request? Yeah, go ahead, Secretary Kelly.
Thank you, Mr. Chairman, members of the committee. About the middle of page 7, House Bill 1470 deals with some abusive litigation that's taken place towards some of our small business owners as it relates to lawsuits being threatened as in violation of our ADA federal statute. The language that sits before you is compromise language from our small business community and the trial bar that passed unanimously out of the Judiciary Committee.
Any questions? I don't see any. You have a question? Okay. Chairman Williams.
Thank you, Mr. Chairman, and to Vice Chair Kelly, thank you very much for asking for this bill. Is it not true that this is a relatively new phenomenon of these out-of-state abusive lawsuits that are punishing many of our web-based small businesses in Georgia? Is that not true?
It is absolutely correct, and I have a strong history of supporting measure tort reform efforts when I think they're necessary.
Okay. Did you go ahead, leader?
Thank you, Mr. Chairman. On page 7.
Hold down the laughter now. Come on.
On page 7, House Bill 1437, just presenting this on behalf of Representative Gaines. This is the in-person electronic notary bill. Georgia is one of 4 states currently in the country that does not allow for this. As long as the parties are in person, the document could be notarized electronically on, say, an iPad or similar device.
Okay. Don't see any questions. Thank you, sir. Okay, Chair Lady Cooper, you have a request?
Thank you, Mr. Chairman. It's House Bill 500. I've worked on it with Jay Paul for a couple of years. It's to try to help
Came
our
out
poor.
yesterday. It came out yesterday.
Came out yesterday. It's 500. It's to help our poorest of the people who use our TANF assistance. We tried to give them some more money. The amount they have has not been raised in 30 years, and a family of 3 gets $210. That was going to cost too much, but in talks with the commissioner, we thought we could help them a little bit if they could have one car. Before, the car could only be valued at about $3,000, and you know how a $3,000 car would run. And so they could have one car and another one up to worth $4,650. And basically, they could have $5,000 in backup and savings. A lot of these people are our grandparents taking our children that are in state custody and raising them to help us out. Thank you very much.
Okay. It's not in the book. Don't see any questions. Okay. Chairman Jaspers.
Thank you, Mr. Chairman. I asked the committee to take a look again at House Bill 810. That's the bill we passed, looked at a few weeks ago, went back to committee, back and forth a few times. The main change is that we're now limiting the application of this law to independent pharmacies of ownership of less than 10 pharmacies.
Okay.
That's it.
Came out yesterday.
Yes,
Okay.
sir.
Okay. Don't see a question. Chairman Powell.
Thank you, Mr. Chairman. I'd like to ask the committee on House Bill 467. This amends the Monument Protection Act for the benefit of the local governments. There's been so much litigation and all filed over the years on this issue. It sets forth a pathway so that the local governments, if they want to relocate or remove statuary or monuments, that they can do so without it being a constant thorn in the side in litigation.
Okay.
Second bill, if I may.
Wait just a second. It came out yesterday. That's not in the book. Go ahead with the other one.
Second bill, I've already spoke on. It's just a very simple House Resolution 1348 that will allow a constitutional amendment to give those counties, if approved, the option if they want to elect their school superintendents.
Okay. 1348. Representative Miller, did you have a question?
Mr. Chairman. Thank you, Mr. Chairman. Thank you, Mr. Chairman, for the bill. I just had a question about does this bill, or is this bill inspired by a particular monument, or does it in any way deal with the city of Atlanta?
This does not. This would have a statewide effect. This has not only been Atlanta, but it's been across the state, even though it doesn't seem to be as prevalent today. But when local officials want to remove or relocate monuments, the process is not simple and it's been embroiled in litigation. This basically sets forth that if a local government wants to relocate or remove, that they post a notice for 90 days to have the hearings, and once they find a willing donor who will take that statue or that monument, then they're allowed to do so. And the local government has that control so that scurrilous and questionable crowds can't get control of them, but they can then relocate them and gets it out of the litigation system.
But is there some reason why we are not allowing local governments to deal with monuments that exist in their jurisdiction? Is there some reason why we have to make this a statewide issue?
Because it is a statewide issue. The center of the world doesn't just revolve around Atlanta. You have other jurisdictions and other counties and cities that may wish to relocate or to remove a statuary.
But does something preclude a local jurisdiction from doing it now?
It's called lawsuits.
Okay. Whip Burchett has a question.
Thank you, Mr. Chairman, for bringing the bill. Isn't it true that we passed a law, I think it was 19 or 20, that made it illegal for local, any entity to be able to move monuments, and still we have jurisdictions, both cities and counties, that are breaking the law. Isn't that true, Mr. Chairman?
That's absolutely true. What you also have under the current statute that was passed several years ago said that they could move these, but they had to be moved to a prominent location. Well, that being said, there has been no prominent location, and a lot of them do not want to, for whatever reason, they haven't been. Some have been relocated and others have not. Some of them are sitting in warehouses. Some of them we don't even know where they are. But this would give the cities and the counties a clear pathway to avoid litigation, that if they want to relocate or remove, then they can do so under a proper procedure.
Thank you for bringing the bill.
Yeah. Representative Evans, did you have a question?
I do, yes. Thank you, Mr. Chairman. Mr. Chairman, and I haven't had a chance to look at the bill because I don't also see it in our book, but I had heard some concerns that the standing to sue if you're not happy with what a local government is proposing to do with a statute, that can be any interested person. That could be anybody. They don't have to live in the county or city. They don't have to pay taxes. They don't have to even live here as far as I'm concerned. Is that accurate? I just can't confirm it because I can't see the language.
What I can tell you, being a non-attorney, is that this has been embroiled in litigation. There are people who have a vested interest, whether it be a historical group or a private citizen. This allows them to do so. The courts have ruled that if you don't have any direct relationship, and these are statutes that were put up 150 years ago in a lot of cases, so there's nobody that can claim that they had an actual interest of ownership in them. So this basically allows for this to happen by cleaning the language up and getting rid of the inconsistencies of law.
So it's meant to expand the people that could have standing to sue over monument movement. I think that's what I heard.
Yes, ma'am. I think we all have a vested interest at some point toward statues and monuments.
And where do we draw the line? I mean, we're going to name some roads later today probably. Sometimes those change over time. People move statutes in and out of inside of buildings, inside cities and counties. They name and rename parks and schools. I mean, where do we draw the line? Why are we going to allow anybody that remotely thinks they have a claim and of an interest in a statute to sue? What's to stop someone from claiming an equal protection concern because they can't sue over the name of a park that perhaps used to be named for their family member that's not anymore?
Well, I would encourage you to look a little bit deeper into this bill because this is for the benefit of local governments. Right now, if they want to relocate or to remove, then it is basically a terrible situation because it gets embroiled in litigation. This gives the local governments a clear pathway and a process that they can remove or relocate monuments.
It sounds like it's going to increase litigation, but I'll look forward to reading the bill once I have a copy in my book. Thank you.
I would certainly encourage you to read the bill.
Chairman Powell, what's that bill number again?
That bill number is HB 467.
467, okay. Thank you. Chairman Gunter. Chairman Gunter, you have a request. Martin, excuse me, go ahead.
Yes, sir, Mr. Chairman. This is also not available yet, but it just came out of higher ed. I think it's an important measure. HB 1413, which includes setting up the scholarship and the framework under student finance for the needs-based scholarship program that the governor spoke about in the state address. It also includes a section for the first in Georgia postgraduate medical scholarships, and it provides some additional stability to the Hope Reserve.
Okay. Don't see any questions there on that. Does that take care of everybody on the committee? Whip Burchett.
To continue the trend, I have one that came out this morning, House Bill 276, and what the bill does is allow for a tax credit for the construction of woody biomass energy producing facilities.
That one will be out later today. Representative Evans, did you have a question on this one?
Sorry, I just was able to look at a copy of House Bill 1413. Chairman Martin, you mentioned at the tail end that part of and I'm so in favor of the needs-based aid bill, I can't see straight. But I see you've added Section 3 that changes the shortfall lottery reserve from 50% of the average amount of net proceeds deposited into the account in the preceding 3 years to 100% when we have over $2 billion in reserves. And this body has spent time making sure that those funds start to get spent down because the citizens of Georgia did not pass a lottery to have a lottery. They passed it to support education. This makes it harder to make sure the money's actually going to go to education, and I just want to know why.
That was a request of the Governor's Office of Planning and Budget and also the appropriations process. And as I said in committee, and I probably should have said it here in rules, the change was requested from 50 to 100. I think that's something that will continue to be discussed as we move it forward, so that we hit the right amount with the new scholarships that need to be funded out of there. We just wanted to be careful with the money. And I know the lady's passionate about that, as am I, to make sure that money is deployed in the right manner. But that was the number that was requested to go into the bill, and we have until April 4th. I think that bill's going to be worked on as we move forward. And I'd be
What
happy
was
to
the
work
stated
with
reason why we would possibly need this? When Hope was first passed, it started out with a 10% reserve. Then in 2011, we raised it to 50. And then we saw time after time that year after year we were stockpiling money that was not going to our students. What in the world was a reason given why we would possibly need to put a reserve this high?
I will let
Was
you,
any given? I'm sorry. Was there any reason given?
I was given the suggestion to do that. And I've spoken with a lady before. We can talk about this now. There's actually additional language that needs to be, worked on in the reserves, because the reserves is required. Now it's measured on the last 3 years' revenue, and I would stipulate that if one is doing a reserve account, you do it on the last 3 years' spending, not revenue. As is written today, if revenue goes down, spending stays consistent, the reserve requirement would go down. You don't want to take a reserve requirement go down while your revenues are going down and your spending is going up. So I understand the lady's concern, and I would just state this: you've been involved in the process for a long time, and you're going to be you're welcome to be involved in the process as those discussions continue. But they had data on which they were relying and asked for that change.
I would love to see the data, and I don't disagree with spending and inputs. That's fine, but that is a big difference between a 50% and a 100% reserve. And my name is on this bill, and I've been talking to people throughout this process, and I have never heard anyone say that we need that. So I would like to see that data right now. If it was presented in committee, it seems like it should be shared right now.
To be clear, what I said in committee was it was 50%. We requested to move it to 100%, and there would be ongoing discussions. I don't have that data myself. I relied on information that I was given from people that you know in the body, and you and I can go and sit with them. I'd be happy to do that with you. I'm being nothing but upfront and honest. I was that in committee, and I'm being that right now. We want to do what's right by the citizens of Georgia, but I think you and I both agree, is it not true, that we want to make sure hope is preserved while we spend at the level that is sustainable.
We absolutely want to make sure that hope is preserved, but this does exactly the opposite. What we really wanted to make sure is that students can go to college. This takes money off the table.
Okay. Got some other questions? Whip Park, you have a question on this?
Thank you, Mr. Chairman. Chairman Martin, while I respect the work you do, I do not recall you mentioning this this morning. So all due respect, again, my hope is that before this is taken up, that whatever reasoning or documentation is provided to Representative Evans as well as members of the Minority Caucus.
I appreciate the gentleman. Just in response to that, I am positive it was mentioned. I know there was a lot going on this morning, but I'll be happy to sit down with you and look at it. Yes, sir.
Okay, we'll get you guys together and y'all talk about that and work all that out, okay? Chairman Linson, you have a request?
Yes, Mr. Chairman, House Bill 868 passed out of the committee yesterday. It's not on the blue sheet. This is a bill that came at the request of the Constitutional Officers Association. It addresses a revenue-neutral way for these long-serving officers to help defray their health insurance expense when they retire between the ages of 55 and 65.
Okay, don't see any question. Jim Chokus, you got a request? Okay.
Thank you, Mr. Chairman. I apologize for being late. I've got two bills that are not on the blue sheet. House Bill 1285 would remove the current prohibition that prevents counties with local option sales tax from also having an enhanced homestead option sales tax. This gives counties that want to eliminate the homestead tax, ad valorem tax, an alternative source of funding. And then the second bill
Hold
is-
on just a minute.
Yes, sir.
Okay, Leader Hughley has a question for you.
Excuse me. Thank you, Mr. Chairman. I didn't quite hear what you said. Would you say that again? Would you repeat what you said clearly?
Okay.
Speak right into the mic, they can hear you better.
Yes, sir. This measure would remove the current prohibition that prevents counties with local option sales tax from also having an enhanced homestead option sales tax. This gives counties that want to eliminate the homestead ad valorem tax an alternative source of funding, and it would only go into effect after a local referendum.
And that one's in your book. Okay. What's your other one?
Next one is a measure that
What's the number?
Chairman, excuse me, 1232, a measure that Chairman Irwin helped me with. Currently, children or Girl Scouts that come to the Capitol, and my granddaughter's a Girl Scout, this is her bill, that come to the Capitol, do not get are not considered present by the school. They're considered absent. And my daughter wants my granddaughter to have perfect attendance. And so about a month or so ago, she was unable to come to the Capitol to visit me in her Girl Scout uniform because she was going to miss perfect attendance. And so that's what this bill does. It allows them to be checked as present, similar to the way the pages are done.
Okay.
And it only pertains to Girl Scouts because my granddaughter's Girl Scout.
Okay, this is in your book. Have a question. Whip Park, do you have a question? Okay, I thought you didn't have a question. Okay. Leader Hughley.
Thank you, Mr. Chairman. Now, I love Girl Scouts too, but we have some other notable activities. Boys and Girls Clubs come here, and several other important entities bring students here. So you're not even including Boy Scouts, you're just doing Girl Scouts?
Ma'am, the Girl Scouts was founded in 1912 in Savannah. I realize the importance of
that. And I've been lugging Girl Scout cookies up here for years because I have a Girl Scout. But
let's do this. Let's ask a question and let's answer a question. Okay.
The question is, I'm trying to understand why are we if this is important, it should be important to all students who are similarly situated. And so that's what I'm trying to get to.
Okay. Representative Miller has a question for you.
Thank you, Mr. Chairman. Have you considered on your Girl Scout bill whether or not it would be subject to an equal protection challenge, because you can't treat one group of folks different than the others? Have you considered that, whether legally the state can treat similarly situated groups differently? And if the rational basis is because it's my granddaughter, do you think that would survive constitutional scrutiny?
it simply allows the child to be considered present. That's all it does.
Okay. No more questions.
Thank
you. No, okay. Okay, I think we've exhausted the wall, we've exhausted the members, and we've exhausted our list. Thank you all for your patience and flexibility. We will meet again later today, I would guess. Probably, I mentioned to you, I think we'll have a lunch break, and we'll have time during that we'll meet. We'll make an announcement and watch your emails, and we'll get that together. So thank you all. I think we can get in time to not make the speaker mad with us. We're adjourned.